In this video, our sole objective will be to understand the parole evidence rule, as codified in Section 202 of Article 2, and the two-part analysis that is required in any application of the rule. As we will see, any analysis of a parole evidence rule issue requires two distinct inquiries. The first inquiry is, to what extent is there a written agreement between the parties, and what is the nature of the writing? Is it a partial integration, or is it a complete or full integration? Or maybe the writing is not an integration at all. The second inquiry goes to the nature of the parole evidence that is extrinsic to the writing. Does it go to merely explain what the writing means, to resolve ambiguity in the written agreement? Or does the parole or extrinsic evidence try to supplement the express terms of the parties' written agreement with additional terms? That is, terms that go beyond what the parties reduce to writing. Or, most problematically, perhaps the parole or extrinsic evidence tries to contradict the terms of the parties' written agreement. Does the parole evidence attempt to suggest that the parties' actual agreement flatly conflicts with what the parties said in their written agreement? As we have already noted, the parole evidence rule applies both to common law contracts and to contracts governed by UCC Article 2. As applied to the sale of goods, the UCC's parole evidence rule is codified in Section 202 of Article 2. This provision is a doozy. It's complex and nuanced. There is a lot going on here. But the basic analysis is simply the same two inquiries that we just noted. What is the nature of the writing, and what is the nature of the parole or extrinsic evidence? Let's start first with the nature of the writing. When there is a writing evidencing an agreement between the parties, the first question that we need to answer is, what type of writing is it? That is because the parole evidence rule applies only to integrated agreements. By integrated, we mean any writing or record that the parties intended to integrate, that is, reduce to writing, the parties' mutual understandings. In the statutory language of the UCC, an integration is a record or writing intended by the parties as a final expression of their agreement. In this context, remember that a writing evidencing the parties' agreement might suffice for the purposes of the statute of frauds, but that writing may not be intended by the parties as a final expression of their agreement. Stated differently, the writing may not be an integration. Where the writing is not an integration at all, the parole evidence rule is inapplicable. For example, imagine that the buyer sends the seller an email confirming an earlier agreement that they made orally. That confirmatory email may be sufficient to satisfy the writing requirements of the statute of frauds, that is, because the email is a signed record evidencing the fact that the parties made an agreement. But presuming that the parties did not intend that email to constitute the final expression of their agreement, then the email is not an integrated writing. It is merely evidence of a prior oral agreement, and the parole evidence rule would be inapplicable to it. To take another example, consider a draft term sheet or letter of intent exchanged during negotiations before a final agreement had been reached. The term sheet or letter of intent outlines the basic terms of a deal that the parties hope to negotiate. But by its nature, the term sheet or letter of intent is merely a preliminary understanding between the parties. It merely creates a framework for future negotiations. It is not a final agreement between the parties as to the deal they are trying to negotiate. Thus, this kind of writing is clearly not an integration. In the language of the statute, the writing was not intended by the parties to constitute a final expression of their agreement. To the contrary, it represented a preliminary, non-binding proposal. So, the parole evidence rule does not apply where the writing or record is not an integration, not a final expression of the parties' agreement. But where there is an integration, 202 says that the integrated writing may not be contradicted by extrinsic evidence of any prior agreement or any contemporaneous oral agreement. But an integrated writing or record may be supplemented by extrinsic evidence that adds to but does not contradict the terms set forth in the writing or record. That's true unless the court determines that the writing or record is intended to be not just a final expression of the parties' agreement, but a final, complete, and exclusive statement of the parties' agreement. Thus, we need to distinguish between two different kinds of integrations, two different kinds of writings. This distinction is integral to the parole evidence rule analysis. Is the writing a final but not exclusive and complete statement of the parties' agreement, what we would call a partial integration? Or is the writing something more, a final, complete, and exclusive statement of the parties' agreement, what is commonly referred to as a full integration. Under 202, for a partial integration, extrinsic evidence may be introduced to supplement the writing or record with consistent additional parole terms, but extrinsic evidence to contradict the written terms is always barred. Extrinsic evidence that would contradict the written terms is never permitted under the parole evidence rule. When we have a partial integration, we think that the parties integrated some, but not all, of the things they agreed to into the writing. But if the writing appears to be more, that is, if the writing is not just a final expression of the parties' agreement, but a final, exclusive, and complete expression of the parties' agreement, then the writing is a full integration. Sometimes courts will refer to a full integration as a total or complete integration. Whatever the courts call it, they all mean the same thing. The parties integrated everything they agreed to into the terms of the writing. Under 202, for a full integration, subject to one exception, the parties are completely barred from introducing any extrinsic evidence to contradict or to supplement their written agreement with additional terms. The one exception is found in subsection A of 202. When section 202 is read altogether, the introductory paragraph says that parole evidence is never admissible to contradict any kind of integration, whether it is a partial or full integration. And under subsection B, in the case of a full integration, parole evidence is generally not admissible to supplement the full integration with additional terms, except that pursuant to subsection A course of performance, course of dealings, or usage of trade is available to supplement an integration with consistent additional terms, even in the case of a full integration. That is because subsection A is not subject to the same unless clause as subsection B, which suggests that under subsection A, you can explain or supplement even a full integration with extrinsic evidence of course of performance, course of dealings, or usage of trade. Comment 2 confirms this conclusion. It says that any record, even a full integration, must be read on the assumption that the course of prior dealings between the parties and usage of trade were taken for granted by the parties when they agreed to the writing representing the full integration. So the parties may have reasonably felt it was unnecessary to commit their custom to writing. Such custom goes without saying. Consequently, customary terms, that is, course of performance, course of dealings, and usage of trade, cannot contradict a written agreement, but they may supplement or qualify a written agreement with additional understandings, regardless of whether the written agreement is a partial or even a full integration. So, to summarize, the first part of the two-part parole evidence rule analysis asks if we have an integrated agreement, and if so, what kind. It is critical to determine what kind of integration it is because it feeds directly into the second part of the analysis. What is the nature of the extrinsic or parole evidence? This second inquiry looks at the relationship between the parole evidence and the written terms of the integrated agreement. Specifically, for what purpose is the parole evidence to be introduced? One purpose for parole evidence could be to help explain ambiguity in the written terms. It could be that the written terms are themselves ambiguous, reasonably susceptible to more than one interpretation or meaning. In that case, a court may resort to parole or extrinsic evidence of any kind to help resolve the ambiguity, to determine the appropriate interpretation of the written terms. Parole evidence is always allowed to help explain ambiguity, regardless of whether the written agreement is partially or fully integrated. So long as the parole evidence is not trying to contradict or add new terms to the written agreement, a court is allowed to use parole evidence to resolve ambiguity, to interpret what the writing or record means. Another purpose for parole evidence could be to supplement the writing, that is, add new terms addressing issues not addressed by the written terms of the parties' agreement. In that case, we just saw that parole evidence is allowed only if the writing or record is a partial integration, because under subsection B, parole evidence of additional consistent terms is never allowed where the writing is a full integration, a final, complete, and exclusive statement of what the parties intended to be bound to. A final purpose of parole evidence could be to contradict, to introduce extrinsic evidence showing that the parties' agreement was actually different and in conflict with the terms of their written agreement. In this case, the parole evidence rule has its most pronounced effect because the parole evidence rule always bars parole evidence that conflicts with the written terms of the parties' agreement. That's true for both a partial integration and a full integration. An integrated writing of any kind always supersedes and discharges any prior or contemporaneous agreements to the contrary. So that's it. That's the parole evidence rule, or at least the very basics of the rule and the two-part analysis that it requires. But there are a lot of details in those two parts, so let's review and make sure we have a firm grasp of the basics before we move on. For the next few minutes, I will walk you through three diagrams to help you visualize the application of the parole evidence rule. Each diagram depicts the two-part analysis differently to give you three different ways to think about the rule. Hopefully, all three will make sense to you. But if you understand only one and the others confuse you, just go with the one that makes sense to you. The first step in any two-part parole evidence rule inquiry requires you to determine the level of integration a writing or record represents. Analytically, the easiest scenario is if the writing is not an integration. The writing was not intended as a final statement of what the parties intended to be bound to. In that case, the parole evidence rule is inapplicable. The parole evidence rule, after all, applies only to integrated writings. So, extrinsic evidence is always admissible for the court to understand what the parties intended to be bound to. It becomes more complicated if the writing or record is a partial but not a full integration. In that case, it becomes necessary to proceed to the second step of the two-part parole evidence rule inquiry, to look into the nature of the parole evidence. If the parole evidence goes to contradict the terms of the writing, that is to suggest the parties intended to be bound to something that was inconsistent with the written terms of their agreement, the parole evidence rule says that that kind of parole evidence is always barred. But if the parole evidence goes to merely supplement the writing, to suggest the parties intended to be bound to additional matters beyond what they reduced to writing, or the parole evidence helps to resolve ambiguity in what the written terms mean, as opposed to contradicting or adding new terms to the writing, in either case, the parole evidence rule says that such parole evidence is admissible. Things get easier again when we're dealing with a full integration. In this final case, the writing represents not just a final, but a final, complete, and exclusive statement of what the parties intended to be bound to. If we're dealing with a full integration, then all parole evidence is barred to either contradict the written terms or to supplement the written terms with consistent additional terms. But even here, note the picture is slightly nuanced because under subsection A of 202, a course of performance, course of dealings, or usage of trade may be admitted to supplement even a full integration with additional consistent terms, even though such custom may not be admitted to contradict the written term. And any kind of extrinsic evidence may be admitted to help resolve any ambiguity in the written terms. Again, not to contradict or add to the written terms, but to help clarify what the written terms mean. You might find it easier or more intuitive to apply the two-part analysis in reverse order, starting first by looking at the nature of the parole evidence and its relationship to the writing or record. Here, analytically, the easiest place to start is with extrinsic evidence that goes to resolve ambiguity in the written terms of the parties' agreement. As we have said, if the issue is that the parties' written agreement is ambiguous, that is reasonably susceptible to more than one interpretation, then parole evidence is always admissible to help the court resolve the ambiguity. Likewise, if the extrinsic evidence would go to contradict the terms of the parties' written agreement, then here the parole evidence rule is in its strongest form. Parole evidence is always barred to contradict the written terms of an integrated agreement, regardless of whether the agreement is a full or partial integration. The most complex scenario is if the extrinsic evidence would go not to contradict the terms of the parties' written agreement, but would supplement the written agreement with additional consistent terms. In that case, the parole evidence rule requires us to perform the other part of the two-part inquiry, to assess the writing to determine what level of integration it represents. If the writing is not an integration of any kind, that's the easiest scenario because in that scenario, the parole evidence rule is inapplicable. Parole evidence of any kind is always admissible where there is no integrated writing. But if the writing is an integration, we must determine what kind of integration it is. Because in the case of a partial integration, parole evidence is always admissible to supplement but not contradict the parties' written agreement with additional consistent terms. But in the case of a full integration, such parole evidence is generally barred. We must say generally, though, because as we have noted under subsection A of 202, course of performance, course of dealings, and usage of trade may be admitted to supplement even a full integration with additional consistent terms, though such custom is never admissible to contradict the written terms. One final way to think about the parole evidence rule is to simply collapse the two parts of the analysis into one step and state the general rules that result. Again, the easiest place to start is where there's no integration of any kind. If there's no integration of any kind, the parole evidence rule is inapplicable. Parole evidence of any kind is always admissible where there is no integrated writing. Where we have a partial integration, however, extrinsic evidence may be admitted to supplement but never to contradict the written terms of the parties' agreement with consistent additional terms. Likewise, as we have said, parole evidence is always admissible to help the court resolve ambiguity. If the issue is that the parties' written agreement is ambiguous, reasonably susceptible to more than one interpretation, extrinsic evidence is admissible to help resolve that ambiguity. That's true both in the case of a partial integration and in the case of a full integration. But otherwise, in the case of a full integration, extrinsic evidence is barred to either supplement or contradict the written agreement, except that under subsection A of 202, as we have said, course of performance, course of dealings, or usage of trade may be admitted to supplement even a full integration with additional consistent terms, though such custom may not be admitted to contradict the written terms. So to summarize, in this video we identified and learned how to apply the two distinct inquiries required in any parole evidence rule analysis, looking at the nature of the written agreement and its level of integration, and then the nature of the parole or extrinsic evidence, and whether that evidence would contradict or supplement the writing or resolve an ambiguity in the writing. In the next video, we will delve into some of the details of the two-part inquiry, looking more closely at how the level of integration is determined and when is a written agreement ambiguous, requiring parole evidence to clarify the ambiguity.